I'm here to tell you about a man who was savvy with his money. The evidence will show that he had some bank accounts and some highly profitable investment accounts in Las Vegas. I'm here to tell you about a thoughtful husband. So much that he took out a life insurance policy that if tragic struck, his wife would be taken care of. Well, tragedy did strike, and that thoughtful provision that Clint took became a reality. That's why we're here today. Today you'll meet Officer Jensen. Detective Jensen, he'll take the stand and he'll tell you what the crime scene looked like when he responded. He'll walk you through his investigation. And I anticipate he'll tell you why he thinks this is just an accident. And then next, you're actually going to meet Clint Harbor's wife, Krista. And Krista Harbor, I anticipate she'll tell you, Clint, he was so much more than a paycheck. He was a person. Krista will also tell you that just weeks after Clint's funeral, she received a recall notice in the mail for Clint's shotgun. That recall notice said that the same gun Clint was claiming the night of his death was experiencing accidental discharges. Now, members of the jury, it is the defense's job to prove to you by preponderance of the evidence that Clint killed himself. That is their promise to you. They have to show you that Clint committed suicide. Now, no one can bring Clint back. No one can change what happened that night on June 14th, 2019. But what you can do is bring some comfort to Miss Harbor. At the end of today's trial, my co-counsel, Mr. Bell, will come before you, and he'll ask you to find for the plaintiff, because the evidence will show that this was just an accident. Clint Harbor was so much more than a paycheck. He was a person. Thank you.
All right, thank you. All right. Is the defendant prepared to proceed with this case in chief?
Yes, Your Honor.
You may call your first witness.
Thank you. At this time, the defense would like to call Stevie Wilker to the stand.
If you'll step forward, sir. I believe you've already been sworn.
May I proceed, Your Honor?
You may.
Will you introduce yourself to the court?
Yes, sir. My name is Stevie Walker.
And Mr. Walker, what do you do for a living?
I'm a private investigator for the Southern Comfort Life Insurance Company.
And what brings you to court today, Mr. Walker?
I was assigned Mr. Harbor's case by Southern Comfort.
And are you being paid in any way for your testimony here today?
Well, that depends, sir. You see, Southern Comfort pays me based on my results. They pay me 10% of all the money that I saved the company.
And would this in any way affect the truthfulness of your testimony in today's trial?
No, no, sir. You see, if I lied on the stand, Southern Comfort would find out, and then not only would I get 0%, but I'd be out of a job from tomorrow morning.
Now, Mr. Walker, you previously said you were an investigator. What education, if any, did you undergo to be qualified for this position?
Well, I underwent numerous different education degrees. I first obtained my associate's degrees at the Crime Scene Investigation School in Ropesville. I earned those degrees in crime scene investigation and forensic analysis. Then I went to the University of Lone Star, and I earned my degrees in criminology and crime scene analysis, both bachelor's degrees.
And what did you do with this education?
After I earned my bachelor's degrees, I went to work for the Dallas County District Attorney's Office as a crime scene investigator. I did so for the better half of over a decade.
Now, in preparation for your investigation, what, if any, evidence did you review?
Well, I reviewed multiple pieces of evidence. First, I obtained the death certificate and the autopsy report of Mr. Harbor. Then I visited Mr. Harbor's apartment to examine for evidence, which I found multiple pieces of evidence there and examined them as well. Then I also took the affidavit of one of Mr. Harbor's neighbors, Mr. Mitch Murphy. And then I went to the police station and I examined the weapon that was used in the death and examined it and found fingerprints on it.
Now, would your specialized knowledge and experience help the jury understand that evidence in today's case?
Yes, sir, I would think so.
And is your testimony here based on sufficient facts and data?
Yes, sir, absolutely.
And have you applied reliable principles and methods to these to the facts of today's case?
Yes, sir, I always do.
And are these reliable principles and methods common in your field?
Yes, sir. People in my profession rely on these all the time.
This time, Your Honor, I move to certify Mr. Stevie Walker as an expert in crime scene investigation and analysis.
Is there any objection?
Yes, Your Honor, we object to that. We object that under 702C through D, that Mr. Walker did not rely on sufficient facts and data or a reliable method to reach this conclusion. Now, we don't mind that Mr. Walker be tendered as an expert in the field generally, but in this case specifically, we do disagree with that.
All right, the court is going to allow the witness to testify based on training experience, the matters that have been discussed here today, but you will be allowed to cross and any issues regarding the weight that should be afforded his testimony can be addressed then.
Yes.
Thank you.
Absolutely.
May.
Now, Mr. Walker, how did you come across the case of Mr. Harper?
Well, Southern Comfort assigned the case to me after Mrs. Harper entered a $1 million life insurance policy in an unusually short amount of time.
And in investigating in this case, how did you begin?
Well, the first steps I took were to obtain the death certificate of Mr. Harper and the autopsy report.
And would you recognize that autopsy report if I showed it to you today?
Yes, sir, I would.
At this time, Your Honor, I would like to approach or propose a court counsel. Just generally. May I approach the witness with what has been previously marked as joint exhibit 1? Thank you. Stevie, what is that?
This is the autopsy report of Mr. Clint Harper,
How do you know that?
because it says so on here, and it's the same document that I reviewed earlier.
And since you reviewed that, have there been any substantial changes, alterations?
No, sir, it seems the same.
At this time, Your Honor, may I publish to the jury, or may it be published to the jury, marked as an exhibit?
Is there any objection, counsel?
No, Your Honor.
It may be.
Thank you. Now, what, if anything, in this document helped aid your investigation?
Well, the autopsy report showed me that Mr. Harper died from a gunshot wound to the abdomen.
Now, what did you do next in your investigation?
Well, after I obtained those documents, I went to Mr. Harper's apartment and I investigated the scene for clues.
And what did you find in Mr. Harper's apartment?
I found the bank note, and some other, I found a letter from a bank and a few other documents as well.
And would you recognize that bank letter if I showed it to you today?
Yes, sir, I would.
For court counsel. The address, date, address, reasoning, and the content of the letter itself. May I approach the witness with what is marked for identification purposes as exhibit number 3?
Yes, you may.
Now, Mr. Walker, do you recognize this document?
Yes, sir, I do.
And what is that document?
It's a letter from the Armadillo State Bank,
And how do you know that?
because it's the same letter that I found at his apartment.
And in that document, have there been any substantial material changes to it?
No, sir, it's the same document.
Now, what in this document helped aid your investigation in the death of Clint Harper?
Well, the document I noted that it was mailed to the apartment at 2121 Drury Lane, which is where he was living at. And then I also noticed that the bank was notifying Mr. Harper they were accelerating his loan of
Objection, Your
$285,000.
Let's hear the objection.
This document is hearsay. They have not laid foundation that this document, that Mr. Walker was custodian of this document. We do not know where this document came from, so we would object that it is inadmissible.
Your Honor, as witness testified, he found it in the apartment of Mr. Harper, and we are going through the certification process to determine where it came from, who it was signed by, and only this, but I feel we believe that it meets hearsay exception 8036, the business record exception. See, the bank kept this, or usually sends letters in the regular course of its business, and it was certified by the vice president of the bank, Ms. Christy Jones. This document doesn't lack any trustworthiness that we can find in today's case, and I believe it should be let in on those grounds.
All right, anything further, counsel?
Yes, Your Honor. Under 8036, this is not an exception under the business record rule. Opposing counsel has failed to state that Mr. Walker was custodian of this document. The bank, Ms. Jones, is not available to testify today, so that we do say that this document should be thrown out because it is inadmissible under hearsay.
All right, the court The court is going to allow the introduction of the document. Again, there'll be wide open cross-examination permitted, so I am going to allow it.
Now, Mr. Walker, what, if anything, did you notice about that document to help aid your investigation?
Well, I noticed that the bank was informing Mr. Harbor that they were accelerating his loan of $285,000 that he owed them. It was all to be paid due at once now. And I also noticed that it was mailed to his apartment at 2021 Drury Lane, apartment 1A.
And was that the completion of your investigation of this document?
Yes, sir. I noticed that it was a regular bank document signed by their VP and everything.
This time, Your Honor, may I publish Defense Exhibit 2 to the jury?
Yes, it's been admitted to you, ma'am.
Yes, thank you. Now, Mr. Walker, after you found the bank letter at the scene of Mr. Harbor's apartment, what steps did you take next in your investigation?
Well, after I examined the letter in the apartment, I spoke with Mr. Mitch Murphy and Mr. Harbor's neighbors outside of the apartment, and I took his affidavit.
And would you recognize that affidavit if I showed it to you today?
Yes, sir, I would.
For court and counsel. The first sentence of paragraph 2, as well as the contents. May I approach the witness with the same, Your Honor? Now, Mr. Walker, what is that?
This is the affidavit of Mr. Mitch Murphy,
How do you know that?
because I'm the one who took it from him.
And have there been any changes since you took that affidavit?
No, sir, it's the same.
And could you testify to the reliability of that document?
Yes, sir, absolutely. Not only did I take it from him, but he also signed it. It was notarized, and he swore to tell the truth.
Now, what, if anything, in that document helped aid you in your investigation?
Well, Mr. Murphy pointed out to me that Mr. Harbor had just
Objection, Your Honor. This document is hearsay within hearsay. May I be heard?
You may be heard.
Under Rule 805, this affidavit in itself is hearsay, but it also contains statements that the person who actually wrote this document heard from Mr. Clint Harbor. We ask that those statements not be let in.
May I be heard, Your Honor?
Amen.
We are not attempting to elicit testimony from the witness that would allow those statements to come in, but simply an observation from Mr. Mitch Murphy about what his rationally based perception about Mr. Harbor moving into this apartment on or about June 1st, 2019. Mr. Murphy has certified in this document that he swore to tell the truth, and it was signed and taken before a notary public. This would be a circumstantial guarantee of trustworthiness, and I believe that it should be let in just on those grounds. If you wish to enter a limiting statement to those grounds, we would be more than fine with that as well.
Anything further, counsel?
Yes, Your Honor. Under 801C, this document, this affidavit is hearsay. Stevie Walker is not the declarant, and that Mr. Mitch Murphy in his affidavit is stating to what he heard from Mr. Clint Harbor. Now, if this affidavit is let in, we do ask that those statements within the document that what Mr. Mitch Murphy heard from Mr. Clint Walker be redacted.
All right. The court is going to allow the document in because I think the statements, I think they are being offered not to prove the truth of the matter that is asserted, but just that was the impression or the feeling of the declarant at the time. And so I think that together with, well, I think on that basis, I'll let it in. I will give a limiting instruction to the jurors at the time of jury instructions, if you'd like, to the effect that it's not offered for the truth of the matter, that is to prove the truth of whatever the husband felt about the wife, but just that that's what he was willing to say his feelings were.
Yes, Your Honor, we do ask for a limiting
All right.
instruction. Thank you.
May I proceed, Your
You
Honor?
may.
And Mr. Walker, what in this affidavit helped to aid your investigation?
Well, the first thing I noticed was that Mr. Murphy told me that Mr. Harbor had just recently moved into the apartment at 1A. He told me that he was doing so because Mr. Harbor was separating from his wife after he found out she was cheating on him with a close friend of his.
Now, was this all that you gathered from this affidavit?
Yes, sir, from this affidavit.
This time, Your Honor, may I publish the affidavit to the jury?
You may. Thank you.
Now, Mr. Walker, what steps did you take after you took the affidavit of Mitch Murphy?
Well, In addition to taking the affidavit, I also reviewed the death certificate of Mr. Harbor.
And would you recognize that death certificate if I showed it to you today?
Yes, sir, I would.
Approaching opposing counsel. May I approach the witness with the same?
May.
Now, Mr. Walker, what is this document
This is the death certificate from Mr. Harbor.
and how do you know?
And it's the same document I reviewed, and it says so on it.
And have there been any substantial changes to that document since you last reviewed it?
No, sir, it seems the same.
So what in this document helped your investigation?
Well, the first thing I noticed was that the address listed for Mr. Harbor was the apartment. That Mr. Harbor, his marital status listed at the time of death was married but separated. And I noticed in box 37 that the coroner listed the manner of death was suicide.
And was this all that you used for the death certificate? Is that all that you reviewed?
Yes, sir. Although I did notice that he was a military man, and it made me real sad to see us lose another veteran.
This time, Your Honor, may I enter Exhibit 2 into evidence?
Is there any objection to this exhibit?
We have no objection.
Thank you, Your Honor. Now, Mr. Walker, after you reviewed this death certificate, was that the conclusion of your investigation?
No, sir. Before I concluded my investigation, I went to the Armadillo Police Station and I examined the shotgun that was used in the death.
And what, if anything, did you find relating to that shotgun?
Well, first I was able to look it over, and while I was not able to shoot it in the police station, I was able to observe it, and it seemed functional to me fine. Then I also was able to go over it. I discovered a fingerprint on the trigger guard of the weapon.
And how did you review that fingerprint?
Well, I informed Officer Jensen about it, and then both of us took it to the evidence lab. We ran it, and we determined that the fingerprint was the left thumbprint of Mr. Harbor.
And was that ultimately the conclusion of your investigation?
That thumbprint was on the weapon was his.
Well, no, at that point, were you able to reach a conclusion?
Oh, yes, sir. At that point, I had more than sufficient evidence to reach my conclusion.
And what conclusion was that?
Well, I just looked at all the facts. Mr. Harbor had a recently minted $1 million life insurance policy. He was facing financial hardship. He just separated from his wife. We found out he was having an affair with a friend of theirs. He was living all alone in a small apartment, and his fingerprint was found on the weapon. I was able to make my decision very easily that Mr. Harbor died of a self-inflicted gunshot wound to the abdomen, or in other words, suicide.
Thank you, Your Honor. No further questions. We tender the witness for cross.
All right. Cross counsel,
Yes, may I proceed?
you may.
Thank you, Your Honor. Hello, Mr. Walker. You're getting paid for your time here today, aren't you?
Well, not my time, no, ma'am, just based on the results from the cover.
Right. You actually have an agreement with Southern Comfort Life Insurance Company that if they don't have to pay Clint Harbor's policy, you get 10% of what the original policy is, right?
Yes, ma'am, kind of like a lawyer's contingency fee, I guess.
And that 10% will be $100,000 in today's case, right?
Yes, ma'am, it would be.
With $100,000 on the line, you conducted a very thorough investigation, didn't you?
Absolutely, ma'am. I always conduct thorough investigations.
Part of that investigation, you examined the gun for fingerprints.
Yes, ma'am.
You examined the barrel of the gun for fingerprints.
I examined the weapon for fingerprints. Yes, ma'am.
You examined the stock of the gun.
I examined the gun for fingerprints. Yes, ma'am.
Mr. Walker, you're very familiar with guns, aren't you?
Certain types of guns.
You shot several in your life, haven't you?
Yes, ma'am.
And in order to shoot a gun, you have to press the trigger, don't you?
Yes, ma'am. I'd say so.
And in your investigation to the gun with to the weapon in today's case, you found a fingerprint on the trigger guard, not the trigger. Isn't that true?
Yes, ma'am.
Now, Mr. Walker, you testified to use these certain methods and principles. Are those methods reliable?
Yes, ma'am. Absolutely.
Are those methods peer reviewed?
Yes, ma'am. People in my field use them all the time.
Are those methods that have a gold star standard in your field?
They're the methods that any reliable investigator would utilize.
A reliable investigator. Mr. Walker, when you examined in your original investigation into the death of Clint Harbor, you never actually checked to see if there was an affair going on, did you?
I'm sorry, can you rephrase?
Yes, on direct examination, you testified that you talked to a neighbor, Mr. Mitch Murphy. Isn't that true?
Yes, ma'am. I took it that day.
But you never actually followed up to see if those allegations of what Mitch said were true, did you?
It did not seem necessary in the case. No, ma'am.
So you don't actually know if Clint Harbor was having an affair, do you?
All I know is based off the coroner's report that he was separated, based off of Mr. Murphy's affidavit that he was separated.
That's true. Because actually you only examined 3 things in your investigation, right?
I believe I examined more than that.
Well, I'll refresh your memory, Mr. Walker. You examined the autopsy.
Yes, ma'am.
You examined the death certificate.
Yes, ma'am.
And you examined the actual gun, right?
Yes, ma'am.
And in examining those things, you never wanted to actually talk to anyone else to see if the affair was true, did you?
No, ma'am, I didn't see a reason to.
Thank you, Mr. Walker. And finally, Mr. Walker, you didn't actually know that there was a gun recall on the Browning 870 shotgun, did you?
Well, ma'am, I don't own a shotgun, so I wouldn't have gotten the recall notice.
Southern Comfort Life Insurance Company didn't provide you with that recall notice, right?
Well, I personally don't own the gun. I would not have received the recall notice. I was not aware of it.
Mr. Walker, that's a yes or no question. We are asking about the gun that you examined in your original investigation to the death of Clint Harbor. You never checked to see if there was a gun recall notice, did you?
No, ma'am.
No further questions, Your Honor.
Redirect.
A brief one, Your Honor. May I be heard?
Matt?
Now, Mr. Walker, would there be any reason to doubt the truthfulness of Mitch Murphy's affidavit?
No, sir, not at all.
And when investigating the gun for fingerprints, did you find any other fingerprints other than the trigger guard?
No, sir, the ones that were already discovered by the police were smudged or otherwise already noted. I just discovered the one that they hadn't noticed before on the trigger guard.
Thank you, Your Honor. No further questions.
All right, may this witness be released?
Yes, Your Honor, we got no more questions for this.
You may sit down. Thank you.
Your Honor, at this time, the defense calls Dr. Trevino to the stand.
Doctor, you'll step forward. Stand, please. And I do want to caution the witnesses, when you take the stand to, please, when you do hear an objection asserted, please stop your answer to allow the lawyer to make clear what the objection is before you put the information in, if you can do so. That's right. Thank you.
Good afternoon. Would you please introduce yourself?
My name is Dr. Alex Trevino. I go by Dr. because I have a PhD.
Dr. Trevino, we are permitting witnesses, if they would prefer in the case, to remove their masks for purposes of testimony. Sure. You're certainly not required to, but you may.
And Dr. Trevino, what brings you to court today?
Well, I was asked to come here to speak on behalf of Southern Comfort, to look at the facts and circumstances surrounding the death of Mr. Harbor.
And Dr. Trevino, are you being paid to testify today?
Yeah, I have to make a living as well.
So before we get to your work in this case, just generally speaking, what do you do for a living?
Well, I'm a professor at China Cook University.
What kind of classes do you teach?
I teach psychology and music history.
Did you have to have any education to teach those classes?
Yes, I did my college years at the University of South Dakota. And I moved down to Florida, where I got my master's at Rufus Pennington School of Abnormal Psychology, and then I came back here to Lone Star to get my PhD.
Throughout the course of your education, doctor, what specific subject areas or topics were you focused on?
The psychological aspects of suicide.
Have you ever written or been published on the psychological aspects of suicide?
Yes, I published a book called Superhighway to Suicide.
Now, Dr. Trevino, do you believe that your specialized education and knowledge would help us better understand the facts and issues in today's case?
Yes, I do.
Is your testimony today, is it based on reliable principles and methods?
Yes, it is.
Have you reliably applied those principles and methods in forming your testimony?
I have.
Your Honor, at this time, the defense moves to certify Dr. Trevino as an expert in the fields of psychology with a focus on the psychological aspects of suicide.
Any objection, counsel?
Yeah, sure. On the same objections earlier under Rule 702, we just asked that opposing counsel lay the foundation under 702B through D, that Dr. Trevino actually applied those methods and principles she talked about earlier, specifically to this case before she renders an opinion.
All right, the witness has testified that she did do so in reaching whatever opinion she's going to offer. So at this point, I'm going to allow it. You can reassert the objection if that turns out not to be the case. But that has been the testimony, so the court will allow the witness to be accepted as an expert on the subject.
Yeah, sure.
Dr. Trevino, let's talk about your work in this case. What sort of things did you review in forming your testimony for today?
Well, I reviewed the death certificate, the autopsy report, and the depositions of Mr. C. Walker, Christensen, and Mr. Harper.
Based off those documents and your review of them, were you able to reach a conclusion as to the cause of his death?
Yes, I was.
What was that conclusion?
That it was suicide.
What sort of things did you rely upon, or how did you reach that conclusion? I'm sorry.
Well, there were 4 factors that I based off of. First, statistically, suicide rates are higher in white males between the ages of 55 and 59. Second, suicide is statistically higher in situations where long-term relationships have ended abruptly in divorce or separation. Third, suicide is statistically higher in situations where the decedent was intoxicated. And fourth, suicide is statistically higher in situations where the decedent has ready access to lethal weapons.
Have you created an expert report that outlines those factors?
Yes, I have.
If I showed you a copy of it, would you recognize it?
I would.
Your Honor, I'm now approaching opposing counsel, what's been previously marked for identification purposes as Exhibit 7. Do I have permission to approach the witness with the same?
Okay.
Dr. Trevino, can you tell us what that is?
This is my expert report.
And you know that because you wrote it. Has it been changed at all, or any alterations to it?
No.
Your Honor, at this time, the defense moves to enter Exhibit 7 into evidence.
No objection, Your Honor.
So allow in.
Do I have permission to publish to the jury?
Amen.
Now, Dr. Trevino, let's walk through those factors one by one. What was your first factor?
His age and sex.
And how do you know Mr. Harper's age and sex at the time of his death?
I believe it was on the autopsy report.
That autopsy report's been entered into evidence. So what did you learn from that autopsy report?
I learned that Mr. Harper was a 57-year-old man.
And that fits into the second factor you just told us about.
Yes, it fits into the
First.
Mhm.
Now, let's move to your second factor, Dr. Trevino. What was your second factor?
The end of a long-term relationship.
And what was Mr. Harper's relationship status at the time of his death?
He was separated from his wife of 26 years.
How do you know that they'd separated?
I learned this from C.B. Walker's deposition.
And what did you learn when you were reading through Mr. Walker's deposition?
Well, I learned that he had recently moved into the apartment about 2 weeks prior after separating from his wife of 26 years due to her marital infidelity.
Now, doctor, let's move on to your third conclusion. What was your third conclusion?
That Mr. Harper was intoxicated.
How intoxicated was Mr. Harper at the time of his death?
He had a blood alcohol content of 0.18.
Generally speaking, at what level is a person legally rendered intoxicated?
0.08.
So in your professional, psychological opinion, how was he able to reach a blood alcohol content of 0.18 and still be functioning?
He was likely an alcoholic.
Objection, Your Honor, to improper opinion. May I be heard?
You may.
Opposing counsel hasn't laid any testimony about how Dr. Trevino has analyzed that BAC, if she has any knowledge or experience calculating BACs, how someone interacts with alcohol in their system. Right now, she's an expert in psychology with a specialization in suicide. We've heard no foundation under 702 for that specific opinion, that he was an alcoholic.
If I'm heard, Your
You
Honor.
may.
The witness's opinion, first off, is based upon exhibits that have previously been entered into evidence, the autopsy report and the death certificate. As the witness has testified, she has years of education and training in the field of psychology, with an emphasis on, like I said, the psychological aspects of suicide. This is one of the 4 primary factors that her opinion today is based upon. Therefore, she's more than knowledgeable on this because, like I said, it's one of the factors of her opinion today.
I don't find it's reliable as to whether or not this gentleman is an alcoholic. Obviously, the condition, we've admitted the blood alcohol content, and it is what blood alcohol content is, but this witness's opinion as to whether or not he was or was not an alcoholic based on these facts is not going to be allowed.
Yes, Your Honor.
Your Honor, move to strike that answer specifically from the record.
It will be stricken, the jury so instructed.
Dr. Trevino, have you written about alcohol in your book?
Yes, I have.
So based off your research, education, training, what impact does alcohol have on a person's ability to carry out a suicide plan?
Well, they don't call it liquid courage for no reason.
And is your opinion that someone could form the intent to commit suicide before they drink alcohol?
Yes, absolutely.
Let's move on, Doctor, to your fourth factor in your conclusion. What was that fourth factor?
Having access to a lethal weapon.
What lethal weapon did Mr. Harbor have access to?
He owned a Browning pump shotgun.
And to kind of wrap all this up together, based off everything you've just told us, all four of these factors, what happened here?
Well, after finding out that his wife of 26 years was having an affair, Mr. Harbor moved into a small domed apartment. The separation, combined with growing financial pressures, led to him to become increasingly depressed. These pressures eventually became so severe that Mr. Harbor decided to end it all.
Objection, Your Honor, specifically to that opinion under 702, may I be heard?
You may.
Now, that opinion right there, that Mr. Harbor decided to end it all, that's what we're here in trial deciding for fact with the members of the jury. So her saying what he explicitly did that night is improper under 702. She can say what she believes happened, but deciding definitively in that answer what did happen, that's for the jury to decide, not Dr. Trevino.
I agree. Excuse me, go ahead.
I was just saying, if I may respond, Your Honor.
Okay.
What the witness is doing right now is she's wrapping up all of the testimony that she's just provided, walking us through each of those factors and rendering her expert conclusion as to what happened in this case. As she testified, she was under immense pressure. She just walked us through all of that. And as opposing counsel stated, she's allowed to offer her opinion as to what she believes happened based off that investigation.
She's been permitted to testify as to her opinion, but now she's attempting to testify to more than opinion in the court's view. It sounds to me as like it's been stated as a fact rather than an opinion which has already been offered into evidence. So if it's redundant, among other things, so I think that as well will be stricken.
Yes, Your Honor.
Yes, Your Honor. Dr. Trevino, what, if anything, would indicate this was an accidental death?
Nothing points to this being an accident.
Nothing further at this time, Your Honor. We tender this witness for cross-examination.
Thank you.
I proceed, Your Honor.
You may.
Good afternoon, Dr. Trevino. I just got a few questions for you.
Sure.
So you refuse to believe that this could have been an accident, like you just said, right?
I don't see anything that says that this was an accident. No.
Actually, nothing could convince you that this was anything other than suicide, right?
Based on the information that I have, yes, nothing can say.
I just want to be very clear. You never talked to Clint Harbor.
Correct.
You never even met Clint Harbor.
That's correct.
You have no way of knowing exactly what he was thinking the night he died.
I mean, I wouldn't have, studied suicide if I had to talk to every single person that killed themselves. That's not possible.
Well, Dr. Trevino, redirecting back to my question.
Sure.
You don't know exactly what Clint Harbor was thinking the night he died, right?
Sure.
You actually base your conclusion off those four factors you mentioned on direct examination.
Yes.
It's age. Yes.
Yes.
The access to a weapon, right?
Yes.
The level of intoxication
Yes.
and the end of a relationship.
Yes.
Let's walk through those one at a time, starting with age. You believe that it's more likely that Clint Harbor committed suicide because he's between the ages of 55, 59, right?
I don't believe that. That's what statistics tell me.
That's right. That's actually based off statistics.
Yes.
Now, just because someone meets that statistic, it doesn't mean they will commit suicide, right?
Sure.
Moving on to that second factor you analyze, access to a weapon. You believe it's more likely that Clint decided to commit suicide because he had access to his .870 shotgun.
Yes, people with access to lethal weapons are more likely to commit suicide.
You base that off statistics.
Correct.
But again, just because someone meets that statistic, it doesn't mean they will commit suicide, right?
Sure, but the more you have in line with the same statistic, of suicide, the more likely it is. Statistics.
But that's a yes to my question. Just because someone meets that statistic, it doesn't mean they will commit suicide, right?
Sure.
So you're actually aware that a gun cleaning kit was found beside Clint Harbor's body.
Yes, I believe I did read that.
So it's possible the night he died, Clint Harbor was actually cleaning his gun.
It just does not seem likely, according to everything I've seen.
So you don't believe that Clint Harbor would have been cleaning his gun since a gun cleaning kit was found next to his body?
I mean, I've never visited his apartment, but I've heard it's pretty small. There's not a lot of places to put things. Things get put places.
Well, Dr. Trevino, you actually analyzed a gun recall notice for your conclusion in this case.
I don't believe I did, no.
It's your testimony that you haven't seen a gun recall notice in your investigation?
I used the autopsy report, the death certificate, and depositions.
So, Dr. Trevino, it's your testimony today that you've never seen a gun recall notice.
No, that's not what I looked at to make this conclusion.
You remember being deposed before this trial?
I was not here when things were proposed, so.
So it's your testimony, you don't have a deposition for today?
Which deposition?
The one you gave before trial.
Oh, my deposition?
Yes.
Yes, I have my deposition. I was there.
I was there.
Sorry.
I was there, right?
I think so, yeah.
And Mr. Marsh, he was there too.
Yes.
Oh, you gave this deposition under oath, right?
Yes.
And you recognize if I showed it to you today.
Yes.
Your Honor, approaching opposing counsel with a witness to deposition.
Met.
Page 4, line 6.
No objection.
Your Honor, may I approach the witness?
Met.
You're welcome. Dr. Trevino, that's your deposition, right?
Yes,
That's your name at the top.
it surely is.
And you gave these answers under penalty of perjury, right?
Yes.
If you can turn to page 4, that last page, specifically to line 6. Let me know when you're there.
Yes.
If you can read line 6 silently while I read it aloud. Now, starting with on line 5, question. Are you aware of a recall on that particular model of shotgun? Answer. Yes, I saw Exhibit 8, the recall notice on the shotgun. I read that correctly, right? May I approach, Your Honor?
Met.
Thank you. Now, Dr. Trevino, you've recognized that gun recall if I showed it to you today.
Yes.
Your Honor, permission to approach opposing counsel.
Met.
No objection.
And may I approach the witness with the same? Would Your Honor like a courtesy copy?
I'm the court.
Yes, Your Honor. Now, Dr. Trevino, this is that gun recall you analyzed, right?
Yes.
Hasn't been changed or altered in any way.
I don't believe so.
It's a fair copy.
Sure.
Your Honor, plaintiff enters Exhibit 8 as next in order.
Is there any objection?
No objection to that, Your Honor.
They admitted.
Yes, Your Honor. Now, Dr. Trevino, this gun recall is specifically for accidental discharges, right?
Sure.
And it's for the same model of gun that Clint Harbor was killed by.
Okay.
Now, that's a yes.
Yes.
Your Honor, permission to approach and publish to the jury.
You may.
Now, that next factor you analyzed, Dr. Trevino, was the end of a relationship, right?
Yes.
You believe it's more likely that Clint Harbor committed suicide because he and his wife were separated.
I don't believe it's more likely. It's the statistics that tell me that it's more likely.
Again, that statistic, that's what you base your conclusion on.
Correct. That's what my field is in.
And again, just because someone meets that statistic doesn't mean they will commit suicide, right?
Sure, but the more points they have statistically, the more likely they are to have done it, right?
Yes, but specifically to my question, that was a yes, that just because someone meets that statistic, it's not, they won't definitively commit suicide, right? Now, if someone isn't separating, this factor doesn't matter, right?
What do you mean?
If someone's actually not going through the end of a relationship, this factor isn't considered for suicide.
For this situation, perhaps.
Well, I actually want to talk about the situation.
Okay.
Now, the only reason you believe Clint and his wife were separating were based off that neighbor's statements, right?
Yes, based off affidavits.
Well, you never talked to Krista Harbor.
Correct.
You never talked to the man she was accused of having an affair with.
No.
So you have no way of confirming if what Mitch Murphy said in that affidavit is actually true.
Correct, but I wasn't brought in here to speak to everybody. I was here to just analyze the evidence.
But that's a no. You didn't conduct your own investigation to see if that factor that you analyzed was actually true, right?
Well, I'm not an investigator.
Objection, Your Honor. As the witness, as stated, this witness has conducted an investigation based off reliable scientific methods and principles, as she has stated. I would ask that, opposing counsel move on from this line of questioning.
May I respond, Your Honor?
You may.
I'm trying to get a clear yes or no whether she did in fact speak to anyone else to confirm if that statistic, that factor she analyzed for her overall conclusion was actually true.
All right, I'll allow witness to answer once more.
Yes, Your Honor. Yes, Your Honor. Dr. Trevino, I'll just repeat this one time. You never did your own investigation to see if that statistic, that factor you analyzed, was actually true.
No, I didn't speak to anybody about it.
Now, the last factor you analyzed was Clint's intoxication, right?
Yes.
Now, that's just how much alcohol he had in the system, time of his death.
Sure.
The night Clint died, his BAC was a 0.18, right?
Yes.
You actually believe that to commit suicide, you have to have the intent to commit suicide, right?
That's correct.
And several factors, they can actually impede this intent.
Yes.
One of those factors is alcohol.
Yes, if the intent hasn't already been formed, then alcohol would keep him from forming the intent.
Now, Dr. Trevino, you can't tell us if Clint had that intent in his mind whenever he died, right?
Sure, but it's a possibility.
You're aware that Clint Harbor, he was heavily intoxicated that night.
Yes, I did read the autopsy report.
And you're aware that if you are that intoxicated, you can't be said to have had the intent to commit suicide, right?
You could if you'd already formed the intent
But,
before you became intoxicated.
but Dr. Trevino, you can't tell us whether or not Clint specifically had that intent at all.
I can't. I'm not in his head.
No further questions, Your Honor.
Please read that, Your Honor.
Yes.
Dr. Trevino. Now, your opinion today is based upon your review of depositions, right?
Yes.
And you've reviewed multiple of those depositions.
Yes.
So how much time had passed between his death and the time that you began your investigation?
At least a year, probably 2.
In your field, is it usual for people to go back and double check those depositions to make sure they're accurate?
No.
Is it normal to go back and try and find your own witnesses on the scene?
No.
Doctor, discussion about alcohol, as you testified, is one of the 4 factors that led to the conclusion. It is possible for a poor person to develop the intent to commit suicide and then get drunk to make it easier, right?
Yes.
Because what impact does alcohol have on a person's ability to carry out their suicide plan?
And people get drunk to do things all the time. That's why they, again, call it liquid courage. Makes things easier.
And Doctor, based off your review of all these depositions, everything in the apartment, all of that, what, if anything, even indicated to you that this could have been an accidental death?
Nothing. Nothing says this was an accident.
Nothing further, Your Honor. We ask that this witness be dismissed.
All right. You might take that. Thank you. All right. Is this the defendant?
No, Your Honor. At this time, the defense rests its case.
The council, do you have some matters before?
No, Your Honor. Since we have the burden of proof, I don't believe we make the direct verdict motion. That's for opposing counsel.
Right. Either of you.
Yes, Your Honor. We actually do request a remove for a directed verdict. May I be heard?
You may.
Specifically under Rule 50, the defense has failed to provide substantial evidence that Clint Harbor committed suicide. As Dr. Trevino testified, suicide has that prerequisite intent. Even when viewing the evidence in the light most favorable to the defense, a reasonable jury could not find that Clint Harbor had that intent to commit suicide, that he actually committed suicide the night he died for 2 reasons. The first being that a gun recall notice was sent out by the manufacturer of the gun that Clint Harbor was using the night he died for accidental discharges. The second reason is that the defense's expert testified for suicide, the individual has to have that intent. That intent can be impeded by things like alcohol. Clint Harbor's BAC that night was a 0.18, and she herself said that he was heavily intoxicated. She can't tell whether or not he actually had the intent to commit suicide that night. With that, we respectfully ask that the court grant this motion.
Your Honor, may I?
You may.
Your Honor, we brought Stevie Walker to the stand and he began to tell you, he walked you through every piece of evidence. He walked you through autopsy, death certificate, affidavits, what he found at the scene, and all of that to reach his ultimate conclusion that Clint Harbor voluntarily and intentionally took his own life. The same can be said about Dr. Alex Trevino, who came up and said that intent can be formed before drinking in order to commit suicide, to make things easier. Now, even if you look at our case in the light most favorable to the non-moving party, we have more than met our burden of proof in today's case by bringing these 2 witnesses and eliciting their testimony to meet or to beat this motion. Not only that, but to win the case outright as of right now. I believe that this motion should be overruled and we should be able to continue with the case in chief.
The court is not inclined to direct the verdict at this time. Based on the state of the evidence, I will not do so at this time.
Yes, Your Honor.
The plaintiff should be prepared to call its first witness.
Yes, Your Honor. With that, the plaintiff calls Detective Jensen to stand.
Step forward.
Proceed.
Okay.
Good afternoon. Would you mind introducing yourself to us?
Hello, I'm Chris Jensen.
What do you do for work?
I'm a detective with the Armadillo Police Department.
Detective Jensen, how are you involved in this case?
Well, I was the lead detective on the death of Clint Harbor.
Before we're talking about Mr. Harbor, I want to talk a little bit more about your background. Did you receive any training to become a detective?
Yes. I was a policeman in the Army for 7 years. I was trained at Quantico. And I joined the force, the Armadillo force, about 5 years ago. So I guess you could say I've been doing this for about a dozen years.
You said you were trained at Quantico. What did that training look like?
Yes, they offer a military police investigation academy, and I got trained in 2 different areas: crime scene investigation along with forensics.
Let's walk through those 2 sets of training one at a time. Starting with crime scene investigation. What did that training look like?
We were trained on how to conduct investigations with all kinds of accidents and crimes, how to start the investigation, what to do when you get to the scene, handling evidence, all that kind of stuff.
Detective Jensen, are military investigations and civilian investigations different in any way?
No, not particularly. If you can have an accident or type of crime in the civilian world, you can definitely have it in the military. The thing about things like thefts, DUIs, or even homicides, our investigations practically the same.
So let's move on to that second area of training you mentioned, forensic analysis. What did that training look like?
Well, we were taught how to collect and interpret fingerprints, as well as conducting both blood and DNA analysis. Sorry, my apologies. Another form of analysis we were taught that people aren't as familiar with is using a scanning electron microscope analysis. I know that's a bit of a mouthful, so we call it an SEM analysis.
Detective Jensen, I'm not really familiar with this kind of analysis. Would you mind explaining what that is?
Sure thing. Use a scientific microscope to scan for electron particles for different substances on an object to determine what all that object might have come into contact with.
Now, do you use all this training as a detective?
Yes, I use all the applicable training each and every time I investigate a new case, such as Mr. Harper's stuff.
I actually want to move on to Mr. Harper's case. How did you get involved?
We received a call on dispatch about a reported gunshot over at Harbor End Apartments a little after midnight on June 15th. It took me about 20 minutes to get there.
What happened when you got there?
Well, I saw a group of individuals huddled together in an outdoor hallway. So I approached and asked them if they'd heard anything.
How'd they respond?
One of them told me she heard a gunshot coming from somewhere over by apartment 1A.
What did you do when you heard this?
I went and knocked on the door to see if that's really where the gunshot came from, of course.
Did anyone answer when you knocked?
No. So I checked to see if the door was unlocked, and it was. So I announced my presence and stepped into the apartment.
Did anyone respond when you stepped into the apartment?
And no. So I proceeded deeper into the apartment.
What did you see whenever you walked deeper into that apartment?
Well, that's when I saw a man lying on the ground. There was quite a bit of blood from what I could tell. It could have been a gunshot wound to the stomach.
Could you tell if this man was alive?
I went to check his pulse, but he had been dead before I arrived.
Were you able to identify him?
Yes, he had a wallet and a driver's license, and it was Clint Harbor.
Detective Jensen, what did you do when you found out that Mr. Harbor was already dead?
I knew the medical examiner was on the way, so I grabbed a piece of chalk and drew the chalk outline of the body's position in case they needed to move him or assist him in any way. But once I did that, I put on a pair of latex gloves and started collecting all the evidence that I would use in my investigation.
Is that method standard?
Yes, you want to preserve the crime scene as much as possible unless you need to take evidence for forensic testing, which is what I was doing.
What all evidence did you collect?
I collected a number of things, a pump action shotgun that was located near the victim's body, as well as a spent shotgun shell that was on the floor. While I didn't collect it, I did take notice of a gun cleaning kit that was on the table.
What did you do after you collected all this evidence?
I took the shotgun and the shell to the lab at the police department and conducted a forensic analysis to test for fingerprints or any other underlying factors.
Is that method standard?
Of course, it's standard in investigation to collect all the evidence that could have led to a death and have it tested forensically to see who all or what it had come to contact with.
Why do you do that?
You want to have a clear understanding of what happened in an investigation, of course, as an investigator. So you piece together the timeline using the evidence and forensics to see what really happened to determine a cause of death.
Did you look at any other materials during your investigation?
Yes, I also reviewed the victim's autopsy report.
You're on permission to retrieve that autopsy report from the jury.
May.
Permission to person witness was already been entered as exhibit 1. Detective Jensen, what about changed?
This is the autopsy report of Clint Harper.
What were you able to learn from this autopsy?
I learned the extent of the damage done to Mr. Harper consisted of a bullet from the shotgun passing through the abdomen and causing a major hemorrhage. This is what led to his death, the shotgun blast. What was interesting, though, was the amount of alcohol in Mr. Harper's system at the time, as well as particles from a rodeo belt buckle that had been retrieved from his stomach by a pathologist.
Let's walk through both of those. Why did you find the alcohol interesting?
The autopsy showed a toxicology report that indicated Mr. Harper's blood alcohol concentration, or BAC, was 0.18 at the time of his death.
What does that mean to you?
To put it in lay terms, it means he had a lot to drink. If I had pulled him over, for example, in my cruiser, and he blew a 0.18, that's over double the legal limit for me to pull him over for a DUI.
So let's move on to that second thing, the belt buckle. Why do you find that interesting?
It was damaged by the shotgun blast, obviously, so particles were lodged in Mr. Harper's stomach and lower abdomen. And Ms. Harper asked us to conduct a lab analysis to determine if there were any foreign substances located on that belt buckle.
What kind of lab analysis did you conduct?
I used that method I mentioned a little bit ago, the SEM. I was specifically looking for the presence of titanium.
When you're conducting this analysis, why are you looking for the presence of titanium?
Well, the primer of a shotgun shell contains titanium. So if the barrel of the shotgun had come into contact with any object when it's fired, titanium would be deposited on that object that came into contact with the end of the barrel.
Detective Jensen, during your entire analysis, did you ever find the presence of titanium?
No, it took about 2 weeks to get the results back, but there was no traces of titanium on the belt buckle or any of the other objects.
What all materials did you review in your entire investigation?
Well, I mean, I had the standard investigation of the crime scene, as well as examining all the evidence I collected, conducting a scanning electron microscope analysis, and then comparing those results to the autopsy to come to my final conclusion.
Are those sufficient facts and data for our conclusion in your case?
Yes, this type of evidence is typically what I use along with the standard procedures I was talking about.
How did you reliably apply those standards and procedures to those facts and data?
Yes, it's how I came to my opinion about the cause of death.
Your Honor, plaintiff moves to certify Detective Jensen as an expert in crime scene investigation and forensic analysis.
May I perform a brief word out, Your Honor?
You may.
May I approach the witness?
You may.
Now, Officer Jensen, you recognize your discharge papers from the military if I showed them to you, right?
Yes, of course, counsel.
May I approach the witness, Your Honor?
Objection, Your Honor, to relevance for this specific document.
For purposes of this board, I were outside the presence of the jury.
Yeah, sure.
So you may address the court with relevance of this document.
Yes, Your Honor. I believe the relevance of this document goes directly to his schooling in the military. You see, it does list that Officer Jensen attended an investigation school, but it never lists a graduation day. It never lists anything that he was trained in. It also lists that he was not an expert in shotguns. Now, he was a rifle and a pistol expert, but these are far different weapon categories than shotguns. And I believe this is necessary to question the witness in this diary.
May I respond, Your Honor?
You may.
That document is specifically discharge papers from the military. So Mr. Hughes can ask Detective Jensen these questions, specifically when he graduated, what he learned at the academy, stuff like that. But it's not relevant to actually enter the document itself, because that document are those discharge papers, not the actual training certification.
I'll allow you to ask him the questions, and then you may or may not be allowed to use the document to impeach him if it's necessary.
Yes, Your Honor.
Yes, Your Honor.
May I approach? Now, Officer Jensen, in box 14, it states that you attended in military. In this,
Perhaps I didn't make myself clear.
oh, I'm sorry.
I'll allow you to ask him questions
Oh, yes, sir.
without the use of the document. In other words, you can ask him if he's trained in guns, shotguns, as opposed to pistols. You can ask him if he received his graduation papers from the training that he had. And then if you need to, perhaps we can get to use of the document.
Yes, Your Honor. I do apologize. Now, Officer Jensen, on this document, it states that you attended investigation school. Can you tell us when you graduated from that investigation school?
Yes, I went to Quantico Military Academy, and I graduated in about 2004.
And during your time at Quantico Academy, were you trained in shotgun usage at all?
Not particularly. I was trained in forensics and other types of guns, but usually with firearms, a lot of things overlap and end up using the same tests.
But not with shotguns, is that correct?
No, sir.
And now, you were subsequently discharged from the military, isn't that correct?
Yes, it's really a funny story. I was working on a case, and a couple pieces of evidence got lost. This, of course, wasn't my fault, but someone's always got to take the fall for everything. So I was less than honorably discharged.
But the reason for this was that you were unable to perform your duties as required of your position, isn't that correct?
Like I stated, a couple of pieces of evidence had gone missing, and I was the one who took the fall for it.
All right.
This time, Your Honor, I move to offer this this witness as a lay witness rather than an expert itself.
May I respond, Your Honor?
You may.
So Detective Jensen still has that same training he mentioned earlier in crime scene investigations and forensic analysis. Nothing Mr. Hughes just asked him actually takes that training away from him. He's already laid that he used the proper standard methods that he was taught in the Army of how to conduct a crime scene investigation, using that scanning electron analysis to determine the presence of titanium. None of that goes away just because he has some discharge papers. He still has that same training and therefore should be entered as an expert under 702.
Yeah, may I, Your Honor? Your Honor, I believe this investigation and these ways of training were particularly geared towards his rifle and his pistol expertise. In this case, it's the case of a shotgun blast to the stomach. I don't believe this witness is qualified to testify as to his methods and principles as they pertain to a shotgun because he is not reliably certified in that field.
May I respond, Your Honor?
You may.
Detective Jensen wasn't saying he was an expert in shotguns. He was just saying that he was an expert in conducting a forensic analysis to see how the shotgun blast interacted with titanium with that scanning electron analysis. We're not entering him as an expert in shotguns in general. We're just asking that he be entered as an expert using those principles and methods for crime scene investigation and that forensic analysis.
All right, I'm gonna allow the witness to testify as an expert in the area of forensics. You may use when the jury comes back, you may approach the witness on cross.
Yes, Your Honor.
Yes, Your Honor. Detective Jensen, earlier you said that method you used helped you come to a conclusion about the cause of death. Is it typical as a crime scene investigator to look for causes of death during investigation?
Yes.
What did you ultimately believe was your opinion of the cause of death as a crime scene investigator?
Well, my final thoughts on the matter, decision on the matter, was that Clint Harper died of an accidental discharge of a shotgun while he was attempting to clean it.
What makes you say it was accidental?
The positioning of the body, the gun cleaning kit found on the table, how drunk he was at the time. These are all factors that point to this being an accident, especially due to the lack of titanium present.
Detective Jensen, why do you keep putting all this emphasis on the lack of titanium?
Well, counselor, it might be easier if I could show you.
You have permission for Detective Jensen to step down and do a physical demonstration?
Any objection?
May I reserve the right to object during the demonstration, Your Honor?
You may.
Thank you.
Step down.
Detective Jensen, if you wouldn't mind just come standing right next to me. What do you mean when you say it would be easier to show us?
Well, if Clint Harbor had put that shotgun against his stomach and then bent down to grab the trigger, when that shotgun went off, the barrel would have had to come into contact with the belt buckle. Now, I found no traces of titanium on that belt buckle, which means there was no evidence of that happening in this case.
Thank you, Detective Jensen. You can retake your seat. Your Honor, we have no further questions and we tender Detective Jensen for cross-examination.
Thank you.
May I proceed, Your Honor?
You may.
Now, Officer Jensen, you were at a nearby establishment when you received the call about Clint Harper, isn't that right?
Yes, I was actually getting frosty at the time.
And you were getting a refreshment at the time that you received the call, isn't that right?
Yes.
And you received this call at 12:04 when you were enjoying that refreshment, wasn't that correct?
Yes.
But you arrived at the scene of Clint Harper's apartment 33 minutes later, isn't that right?
Well, the Wendy's is across town and there was a bit of traffic at the time, but I did get there as swiftly as I could. As an investigator, it's really not my job to be the first one on the scene. That's usually for the patrol officers.
Now, I would ask you if you could limit your answer to a yes or no. Were you or were you not 33 minutes, you arrived 33 minutes later, isn't that correct?
Yes, it took me about 30 minutes to get there.
Now, when you arrived on the scene, you stated that you talked to multiple of Clint Harper's neighbors, isn't that correct?
Yes.
But you didn't take their affidavits, did you?
No, I was more interested in getting to the scene of the crime.
You didn't take any sworn statements during that time, did you?
No, I just asked them if they heard anything or they knew what apartment the blast had come from.
And you were able to find out which apartment it was, and you subsequently entered that apartment, isn't that correct?
Yes, I did.
And when you entered the apartment, immediately after seeing the body of Clint Harper, you drew your chalk outline, isn't that correct?
Yes, it's important to preserve the location of the body in matters like this.
But you didn't take any photographs of the scene before collecting evidence, did you?
I did take one photograph of this.
But isn't it true that photographs can be altered or tampered with in any way?
Yes, that's why I only took one. I really only took a photograph of the chalk outline. But what's funny about photographs and technology these days is photo editing in Photoshop and similar features have made photography a much less reliable form of evidence in recent years.
Now, Officer Jensen, I would ask you to please limit your answer to a yes or no. You did not take any photographs of the scene, did you?
I did take one.
You took one. Now, when you collected evidence, you claimed that you collected a shotgun and a shotgun shell. Isn't that correct?
Yes, I collected both of those.
And you also noticed a gun cleaning kit on the kitchen table nearby Chris Jensen's or Clint Harper's body. Isn't that correct?
Yes,
But you didn't take that gun cleaning kit into evidence, did you?
I did take note of it. It's important to only take things into evidence that we're going to forensically test, and there isn't much reason to forensically test a gun cleaning evidence, a gun cleaning kit, my apologies, as opposed to a possible murder weapon.
Now, one of your main reasons or one of your main conclusions in this case is that Clint Harper died in the process of cleaning his gun. Isn't that correct?
Yes,
And you tested a belt buckle for titanium. Isn't that right?
yes,
But wouldn't it be relevant if you tested the gun cleaning kit if he died at the time that he was using it to clean his gun?
I tested the belt buckle for titanium because, as we all know, the belt buckle was blown to bits by the shotgun blast. Now that leaves two options. Either the shotgun came into contact with it or it didn't. I found no titanium, which means the belt buckle never came into contact with the barrel of the gun.
But Mr. Harper, you claim, was cleaning his gun at the time of his death. Isn't that correct?
Yes,
And you didn't think that it would be relevant to test a gun cleaning kit for titanium either?
Titanium wouldn't have really come into contact with the kit. That's not how the discharge typically works.
Now, you were comfortable only taking these two pieces of evidence in because of your previous military training. Isn't that correct?
Yes, I took both the shell and the shotgun evidence.
And during your time in the military, you were an investigator. Isn't that correct?
Yes,
But during your time as an investigator, you were subsequently less than honorably discharged from the military. Isn't that correct?
Objection, Your Honor, relevance to him being discharged from the military years ago.
Your Honor, I believe this goes directly to the relevance in the case of Officer Jensen being able to perform duty or his duties as an investigator in this case.
I respond to that, Your Honor.
Yeah.
Then I'd like to shift my argument to 404 to improper character evidence. They're trying to elicit this testimony, at least on a good faith basis, we have to believe that they are, to backdoor in improper character evidence, saying that because there's a chance Detective Jensen misplaced some evidence in the past, he had a shoddy investigation in this case. That's textbook propensity.
Your Honor, I'm using this evidence to go to the fact that it's leading up to me asking if he was certified in shotgun analysis, not necessarily discharged for any particular reason. I wasn't even going to touch on that in my line of questioning.
I'm gonna allow it.
Yes, Your Honor.
Now, you were less than honorably discharged from the military, isn't that correct?
yes, that was years ago. I was in my 20s. It was a really different time.
Now, if I ask again, could you please limit your answer to a yes or no?
Counselor, I appreciate your frustration, but the court will instruct the witness.
Yes.
As to how to answer. If you have a concern about how the witness is doing it, please address it to the court.
Of course, Your Honor, I apologize.
No.
Now, during your time in the military, you were certified in rifles and pistols, isn't that correct?
Yes,
But you weren't certified in shotguns, were you?
no, it was not.
Now, after your military training, let's go on to the scene of the death of Clint Harper. Now, after you collected your evidence, you went down to the police station, isn't that correct?
Yes,
And at the police station, you performed forensic evidence on the fingerprints and the shotgun, isn't that correct?
I conducted an analysis on the evidence I collected.
And you performed that analysis on your own, correct?
Yes, with the help of the lab.
Without any other party ordering anything?
I believe the deceased wife, Krista, put in the order for the titanium test.
So Ms. Harper did order you to take the titanium test. You didn't go down to the police station and perform it on your own, did you?
I did perform it.
But you were ordered.
But she did request it as well.
Thank you. Now, during your investigation, you found a fingerprint on the shotgun shell, isn't that correct?
Yes,
And it was the index fingerprint of Clint Harper, isn't that correct? But you also, thank you. You also found some fingerprints on the shotgun, isn't that correct?
yes.
And were you able to determine if these fingerprints were legible in any way?
And no, most of them were smudged. There was one that was a little more intact on the cover of the trigger.
But it's possible that that was Clint Harper's fingerprint, or on the smeared prints on the trigger were actually Clint Harper's, isn't that correct?
It is possible. It's really hard to tell with smeared fingerprints.
Thank you, Your Honor. No further questions.
Redirect, Your Honor.
You may.
Now, Detective Jensen, is there a way to tell when a fingerprint came into contact with that gun?
No, we can just analyze the fingerprint if it's clear enough to decide who it came from.
Did you need any sort of certification in shotguns to aid in your investigation today?
No, I've been trained in crime scene forensics.
No further questions, Your Honor.
All right. Further?
Not for this witness, Your Honor, we just ask that he be excused before our next witness.
All right. I'm gonna set that.
The plaintiff now calls plaintiff, which Krista Tona Harper to stand on. Now proceed.
You may.
Can you please introduce yourself to us?
Hi, my name is Krista Chapona Harbor,
Can I call you Krista?
of course.
Krista, why are you here today?
Clint Harper was my husband.
And do you know what happened to Clint?
Um, All I know is that somehow he was shot in the stomach with his own shotgun. And I've been sitting here all day listening to people who don't even know him say all of these things. The insurance company is saying the policy is not worth anything because Clint killed himself, but my husband would not do that.
Chris, I know this is difficult. If any time today that you need a brief recess or point, just let me know. Now, Krista, why are you here today in court?
Well, because I submitted a life insurance policy that Clint had taken out when I found it, and the insurance company is saying that my husband committed suicide. Because of that, the policy is not worth anything.
We're talking about that life insurance policy. When did Clint submit this policy?
I don't remember the exact date that he took out the policy. I just know that it was probably a year or so before he passed.
Do you know exactly why he submitted this policy?
Yeah. He took out the policy because he had been starting to make some investments, things like rental properties. He had a really large hedge fund, and he just wanted to make sure that if something would ever happen, that I would be taken care of.
Did you ever look into any of those investments?
A little bit, just to kind of see what they were, but like I said, it was rental properties and a large hedge fund.
Do you know what any of those investments look like today?
No, I mean, to be honest, that's been one of the last things on my mind.
Krista, do you have any reason to believe that your husband, Clint, was in debt?
I mean, we were pretty open about our finances. We worked through everything together, and no.
Krista, have you been sitting in court all day today?
Yes, I have.
I'm going to allow you the opportunity to respond to some of the things that the insurance company has said about your husband. So the option of the second apartment has been brought up. Do you have any recollection of why y'all got this second apartment?
I do. It was actually something that we had talked about for a while. It was our second apartment, a place where he'd be closer to work, so he wouldn't have to come home late at night, and he wouldn't disturb me when he came home, and we could have things sent there, but it was ours.
Now, an affair has been brought up. Would you have any reason to be unfaithful to your husband?
No. After 26 years, we thought that we had forever, and we promised each other forever. And I could never do that, not to my husband.
Would Clint have any reason to be unfaithful to you?
Objection, Your Honor. Speculation. This witness cannot testify as to what Mr. Harper would have reason to believe, what he was thinking, anything like that. Those answers call for her to speculate as to his mental state.
You can ask this witness if she believes he had an affair, limited to that.
Yes, Your Honor. Krista, in your opinion, would you have any reason to believe that Clint would have an affair?
No.
Well, moving on to the actual gun. Now, Krista, again, if you need a moment, just let me know. Do you know why Clint obtained this shotgun?
Well, I mean, Clint was a really big hunter. So he had it. He was really, really proud of it. He took it everywhere, and he was cleaning it and taking really good care of it.
Was he experienced with this shotgun?
Yes.
Did the shotgun have any problems?
Yeah, I don't really know that much about guns, but he was saying that it was always having problems of some kind, things getting stuck, lots of problems.
Now, Krista, a recall notice was brought into evidence. Would you recognize that evidence if I showed it to you today?
I believe so.
Your Honor, permission to obtain what has been marked as Exhibit 8. Your Honor, may I approach opposing counsel to see?
May.
Okay. Permission to approach the witness, Your Honor. Now, Krista, what did I just hand you?
This looks like the recall notice that we received in the mail about a month after Clint passed.
And when did you receive that recall notice?
It's about a month after we passed, and I just wish that it had come sooner, and maybe I would still have my husband.
Now, Krista, in your opinion, in your 26 years of marriage to Clint, did you ever think he was depressed?
No,
Alcohol has been brought up today. In your 26 years of marriage to Clint, do you think he was an alcoholic?
no, and that's what's been really difficult for me sitting here today, listening to people who don't know him say he's an alcoholic, but my husband is not a heavy drinker, and he's definitely not an alcoholic.
Krista, when was the last time that you spoke to your husband?
It was that same day. I received a phone call from Clint telling me that he was coming home and that I should wait up for him. So I waited and waited, and it was little things like hearing our song on the radio that made everything worse. And I just felt like I was waiting for him to come, and I feel like I was still waiting for him to come, but he's not coming back.
Thank you, Your Honor. I now tender this witness up for cross-examination.
Ms. Harper, I want to keep talking about your relationship with your husband. Y'all were happily married for 26 years.
Yes,
Throughout that 26 years, Mr. Harper was always a hard worker, wasn't he?
I would say so. That was something that I loved about my husband.
Worked long hours to provide for you and your family.
Yes,
It was because of those long hours, that was why he began staying in the apartment, right?
yeah, we picked a second apartment to be closer to work so we wouldn't have to disturb me when he came home.
So he did it not to disturb you when he got home. He was trying to avoid that.
Yeah, it was for me.
And Ms. Harper, you wouldn't stay there with him during the week, would you?
No, I was at our home.
And so, Ms. Harper, in that apartment, it was at 2121 Drury View Lane.
Yes, I believe so.
And despite the fact that he would stay alone during the week, as you just told us, you had no reason to question your husband's faithfulness to you, did you?
No, absolutely not.
No reason to believe that he might be having an affair.
Absolutely not. Not my husband.
Throughout those days and weeks leading up to his death, he was on top of the world, wasn't he?
I would say so.
Never showed you any signs of depression?
No.
Never showed you any sense that he was under some financial stress?
No.
And Ms. Harper, you're familiar with Armadillo State Bank, aren't you?
Yes.
And that was where you found that your husband's life insurance policy that we're here about.
Yes.
You'd be able to recognize their logo and things like that.
Probably.
So, Ms. Harper, if I showed you a letter from Armadillo State Bank, would you recognize it?
I believe so.
Your Honor, do I have permission to retrieve the Armadillo State Bank letter from the jury? So, Ms. Harper, this is a letter from your bank, right?
It looks like it, yeah.
And the date on that letter is June 11th, 2019.
That's correct.
That would have been 4 days before your husband's death.
Yes.
And the address that letter was mailed to was 2121 Drury View Lane.
Yes, our second apartment.
And it's addressed to Clint Harper solely, not your name's nowhere on there, is it?
No.
So, thank you. So, Ms. Harper, at least as we know, as of June 11th, your husband was now not just temporarily staying at the apartment, but he's receiving his bank mail there too, right?
Yeah, we actually put our address in to have a couple of different things sent there.
But Ms. Harper, once again, your name is nowhere on the letter, is it?
On that one, no.
So, now, Ms. Harper, as you said, the purpose of this was to temporarily stay there during the week.
Yeah, it was a place where he could stay if he needed to, but it was ours.
Ms. Harper, if he had not moved in full time to the apartment, there's no reason for him to have a gun there, is there?
Well, like I said, he was so proud of his shotgun and he carried it everywhere and wanted to make sure that it was in the best condition.
Ms. Harper, are you familiar with your husband's death certificate?
Yes, I am.
So if I showed it to you, would you be able to identify it?
Yes.
Your Honor, do I have permission to retrieve the death certificate from the jury? Ms. Harbert, looking at this death certificate, on your box, let's see here. Number box 9, it says marital, read along with me, it says marital status at time of death, and it indicates on here married but separated, is that right?
It does say that, but like I said, my husband and I were happy.
But Ms. Harbert, the reason that your husband had moved his gun into the apartment and that he was now receiving financial letters there was because the two of you had separated.
We weren't separated. That was our apartment. I don't know why everyone is saying that.
The reason though that your husband had left and moved into the apartment was because you were actually cheating on him with Andy Little, right?
Absolutely not.
But Ms. Harbert, you do know Andy Little though.
I do. We get coffee sometimes and talk, but Andy would never make any improper advances towards a woman, if you know what I mean.
So, Ms. Harbert, you know what Mr. Little looks like, don't you?
Yes,
I'm sure you could identify yourself in a photograph.
yes,
So if I showed you a photo of the two of you, would you recognize it?
probably yes.
Your Honor, I'm now approaching opposing counsel with what's been previously marked for identification purposes as exhibit number 9. I have permission to approach the witness with the same. Now, Ms. Harbert, looking at this photograph, is that a picture of you and Mr. Little?
Yeah, it is. I remember that day.
And looking at this photograph, are you telling us today that the two of you were just friends?
Yes, he was trying to.
Your Honor, objection, Your Honor. We asked that he enter this evidence, opposing counsel enter this document into evidence before he publishes it to the jury, please.
Yes, Your Honor. Your Honor, at this time, the defense enters exhibit number 9, or what's been previously marked as exhibit number 9 into evidence.
Any
No
objection?
objection, Your Honor.
To be admitted in evidence, we may not now publish it.
Yes, Your Honor. Now, Ms. Harbert, looking at this photograph of you and Mr. Little, are you telling us the two of you were just friends?
Yes, like I said, he was looking to see if something was in my eye, and he is not into women.
So, Ms. Harbert, it's safe to say that you can't really tell us what your husband was like in the days and weeks leading up to his death because you weren't living with him anymore.
He was just staying there periodically, and he called me and told me to wait up for him because he was coming home.
Ms. Harbert, let's talk about the insurance policy that brought us here today. Now, the purpose of this policy was your husband wanted to protect you.
Yes, of course.
He was trying to protect you from some investments, as he told us.
Yeah, he wanted to make sure if anything went bad, I was taken care of.
And so to protect you, he took out this $1 million policy.
Yes.
Now, Ms. Harbert, the only way, though, for you to recover on that $1 million is if this jury determines that his death was accidental, right?
I guess so. I only submitted the policy because I found it and I figured it didn't have any good just sitting there. But the money's been the last thing on my mind. I lost my best friend and my husband.
Thank you, Ms. Harbert. But as you've heard throughout today, there's a lot of testimony about accident versus suicide. So the only way for you, though, to recover that $1 million is if the jury determines that his death was accidental.
I guess so. My husband would not commit suicide.
But that's a yes, though. They would have to determine that it was an accident.
I guess so.
Thank you, Your Honor. Nothing further.
Brief redirect, Your Honor.
You may.
Krista, they brought up that picture, the defense brought up a picture of you and Andy. What is your relationship like with Andy Little?
We were just friends. Like I said, sometimes we would go get coffee and talk about life, but he wasn't into women.
Was Clinton living at the second apartment permanently?
No, he would just stay there occasionally.
Would Clint come home on the weekends?
A lot of times Clint would come home, yeah.
Would Clint come home sometimes during the week?
Yes.
Did you receive any mail in the second apartment?
Yeah, we had things sent there all the time.
Do you have any joint banking accounts?
I don't know.
Do you have separate bank accounts?
We use the same bank and we have all of our stuff sent together.
Thank you. No further questions, Your Honor. I now ask this witness to be allowed to step down.
May sit down.
With that, Your Honor, the plaintiff rests our case in chief, and we just ask, time permitting, if we can take a 5-minute recess right before closing.
That'll be fine. Any objection?
Absolutely not.
All right, we will be in recess for 5 minutes, and when we return, we'll have closing arguments.
All rise.
You're getting good.
You know,
I'm not sure yet. I think I will.
That's exciting.
Yeah.
You're like, yeah. All the time conspiracy theory, everybody keeps screwing up. Where are you gonna do it like city groceries? I mean, I like. Down like a little bad time. Then when it's viewed, live music always. You can take it out and you see you're like, yes. Yeah, I was like, that's so. I'm very good into it. Over here, I was like, where'd you go? I was like, yeah, they were way
All rise. Please be seated. Next, a jury will reach a point in the trial where the attorneys will have an opportunity to make what we refer to as closing arguments. We will proceed with the plaintiffs doing the, how are we doing this? I'm sorry, the defense will open for the closing arguments, and then we'll hear from plaintiffs, and the case will be yours shortly.
May I proceed, Your Honor?
You may.
And Your Honor, before I continue, may I please reserve my remaining time today for rebuttal?
You may.
May it please the court, opposing counsel, members of the jury. Every person has a break. And on the night, June 15th, 2019, Clint Harper had finally reached his. Now, as my co-counsel, Mr. Marsh, told you earlier in today's trial, we here are proudly representing the Southern Comfort Life Insurance Company. But make no mistake, we are here today as a result of a tragedy. This tragedy was no accident. Now, to understand this tragedy, we have to walk our way from the beginning to the end. So let's start at the beginning. 1 year prior to Clint Harper's death, he and Southern Comfort signed a contract, and that contract was for a life insurance policy with a base value of $1 million. Now, this policy, like most, had a clause in it, and this clause stated that this policy would be rendered null and void if the person receiving the benefit of the insurance voluntarily and intentionally took their own life. So, ladies and gentlemen, the two signed the contract and went on their own way. But no one could have predicted the pressures that Clint Harper would face in the year preceding. Now, Clint Harper was a man of simple means. He loved nothing than to come home after a long day's work and spend quality time with his wife. But as his work hours grew longer, Clint Harper was away from home. So much so that he made the decision to rent an apartment nearby his workspace. But as work hours grew longer and time went on, this apartment would eventually become his home. Clint Harbor discovered that his wife of 26 years is Robert, having an affair with a dear friend named Little. This was his wife, his home, taken from him in one fell swoop. Now, as the year progressed, ladies and gentlemen, and Clint Harbor moved into this apartment, he received a letter. And this letter was 4 days before his ultimate death. It was from the Armadillo State Bank. This letter was accelerating the loan in the amount of $285,000 to be paid in full. The pressures of losing his wife, the pressures of losing his home, and the pressures of this insurmountable debt led Clint Harbor to his ultimate breaking on the night of June 15, 2019. Now, ladies and gentlemen, as the defense in this case, we have to show you that Clint Harbor voluntarily and intentionally took his own life. And we must do so by meeting our burden of proof. Now, the burden of proof in a case of this nature is by a preponderance of the evidence, more likely than not. But if you're a visual learner like myself, I like to imagine the scales of justice. With each piece of evidence that comes in, with each piece of testimony, those scales will tip ever so slightly in one's favor. Now, how do we tilt those scales in our favor? Well, first, we called Stevie Walker, an expert in crime scene investigation and analysis. Stevie Walker got up here and he walked you through every single piece of evidence he examined in order to come to his ultimate conclusion. He walked you through the autopsy report. He walked you through the death certificate. He walked you through the bank letter, the affidavit, the fingerprint on the shotgun, and his examination of the shotgun. And even after all that, ladies and gentlemen, he was able to come to the conclusion that Clint Harbor had voluntarily and intentionally taken his own life. Next, we brought in Dr. Alex Trevino, an expert in psychology with an emphasis in suicidal tendencies. Now, Dr. Trevino got up here and she walked you through her 4-factor approach. Now, this approach started with Mr. Clint Harbor's age range and gender. So Mr. Harbor was a 57-year-old man. And according to Dr. Trevino and these factors, that man at that age is statistically more likely to commit suicide. Next, she walked you through the marital troubles Mr. Harbor was having. That people at that age that are going through marital troubles are more likely to commit suicide. Next, she walked you through the alcohol or the intoxication at the time of death. Now, Dr. Trevino told you that you can form intent before, but the alcohol may be a way to gain courage to commit that ultimate act. And last, Dr. Trevino told you that Mr. Harbor was more likely to commit suicide because he had access to a lethal weapon, shotgun. Ladies and gentlemen, after this evidence and testimonies come in, you can still imagine the scales of justice. They're not only tipping, but they're at their breaking point. Now, ladies and gentlemen, when you go back and you deliberate today, you'll be charged with answering one question. You'll be asked, yes or no. Did Clint Harbor's life end as a result of suicide? And your answer should be a resounding yes. Why is that? Because the pressures from him being separated with his wife, the pressures of him losing his home, and these insurmountable financial pressures led Clint Harbor to reach his breaking point on the night of June 15th, 2019.
Yeah, before I begin my closing, it's all right if I set the visual aid as well.
Sorry.
Have a seat. Okay, please, court,
Mr. Hughes,
members of the jury. He was a person, not a paycheck. It's few days after Clint Harbor's funeral, Krista's sitting in the bank. She's going through the safety deposit box and she finds their birth certificates, their marriage license, the deed to their house. And then she finds Clint's life insurance policy. So she submits it. She sends it to Southern Comfort Life Insurance Policy Company. And then she does what she's been doing since the last time she talked to Clint. She waits. She waits and she waits. But then she finally gets an answer back. Denied. That's why we're here today. Because Southern Comfort Life Insurance is refusing to honor Clint's policy. They're saying that they're not going to pay that policy because Clint Harbor committed suicide. But why would he do that? Why would Clint Harbor want to take his own life? That is the million-dollar question today. Because of their claim, it was the defense's job to answer that question. They had to show that it was more likely than not that Clint Harbor decided to intentionally take his own life. So let's look at whatever evidence they showed you today to try and prove that theory. First, they brought up some debt that Clint had. They said that according to that letter from the Armadillo State Bank, Clint owed the bank $285,000. But it's important to note what Krista told you on stand today. Clint had several large hedge fund investment accounts. And that note, it wasn't due until a week after Clint had already died. So why would a man kill himself over debt that he had the means to pay off and time to do so? The next factor they brought in to try to convince you of this was an affair. They said that Clint Harbor found out his wife was cheating on him, packed his bags, and moved into their second apartment. But I want you to remember what Krista told you. The night Clint died, he called her. He said, "I'm coming home tonight. Wait up for me." That doesn't sound like a bitter husband who packed his bags and moved out because his wife was having an affair. Sounds like the defense is grasping at straws to keep their case afloat, especially when you consider the fact that the man they're alleging Krista had an affair with isn't even interested in women. But according to the defense, their smoking gun was that death certificate that listed Clint's death as a suicide. But it's important to realize when that death certificate was published. The day Clint died. Detective Jensen told you he didn't get his lab analysis back on that titanium report for 2 weeks. Carissa told you she didn't get that letter about the recall notice until a few weeks after Clint's death. Unlike what the defense believes, it's okay to change your opinion when you get new information. But it's important to remember what Detective Jensen didn't find when he got that report back 2 weeks later. The presence of titanium. He explained to you today that if Clint Harbor had intentionally put that shotgun barrel up against the stomach and bent down to pull the trigger, that shotgun barrel would have came into contact with a rodeo-sized belt buckle he had on that night. The same belt buckle that was damaged in the blast, the same belt buckle that was found in Clint Harbor's stomach. Members of the jury, he told you that because there wasn't the presence of titanium, there's no way that barrel was pressed against his stomach. So there's no way he could have reached around and pulled that trigger. He also told you that the only discernible fingerprint found on that gun wasn't even on the trigger itself. It's on the trigger guard. So how do you fire a gun without pulling the trigger itself? Stevie Walker told you, he said, that's the only way you can fire a gun. You get that answer from this recall notice. It tells you, Browning 870 shotgun, send them in immediately. We have been getting reports of accidental discharges. Members of the jury, that's how a gun goes off without pulling the trigger. But it's hard for the defense to prove their case as to why Clint Harbor committed suicide when their two witnesses can't even agree on that. On one hand, they've got Stevie Walker. Stevie Walker is an investigator that was hired to investigate this life insurance policy and ultimately determine if this was a suicide. I said, Steve, if you can get us out of paying this policy, we'll give you a 10% cut. In this case, that's $100,000. So with $100,000 on the line, Mr. Walker took that stand and told you the reason he thinks Clint committed suicide is because he found his wife was having an affair, he got depressed, and pulled the trigger. But members of the jury, he didn't even realize there was a gun recall on that shotgun. Which is a little interesting when you consider Southern Comfort never told him it existed in the first place. He told you, no one told me about this. But they can tell their other expert, Dr. Trevino, give it to her for her analysis? Why would Southern Comfort not give both of their investigators the same information? Because maybe, just maybe, that would change his mind and they couldn't afford it. Mr. Hughes has been talking a lot about breaking points today. For the defense, their breaking point was $1 million. Instead, they want to give an empty check to Stevie Walker for $100,000 with suicide on the memo line. So the next investigator they bring in that they actually show the recall notice to was Dr. Trevino. Dr. Trevino walked you through her 4 factors as to why she believes this was actually suicide. So let's go through this. The first one, age. According to Dr. Trevino, that's based on statistics. That because we get older, we're more inclined to want to take our own lives. But she told you that just because you meet that statistic doesn't mean you will commit suicide. So we took that out. The next factor we actually talked about was Clint's access to a weapon. We know why Clint had that weapon that night. It wasn't to kill himself, it was to clean it. No one here has disputed the fact that a gun cleaning kit was found next to Clint's body. And we know how it went off by him pulling that trigger because of that recall notice. So you take that factor away. The next factor she analyzed was that end of a relationship. She also told you she did nothing to check and see if that allegation was actually true. Specifically, I wrote it down. She said, it's not my job to go back and double check to make sure people were being truthful. Krista told you herself that end of relationship, that's not what happened. Why would Clint say, I'm coming home tonight, wait up for me, if they were in the middle of getting a divorce? She told you that no one's ending the relationship. This factor doesn't even matter. So we're left with intoxication. How much alcohol Clint had in his system. She told you that alcohol can impede your intent to commit suicide. And if you don't have that intent, you can't be said to have committed suicide. So which is it? Did he have that intent and then get drunk and she's contradicting herself? Or did Clint not have that intent in the first place? No one who testified today could tell you what Clint was thinking when he died. That's important because they have to have that intent to rule this as a suicide. So you take away this factor. And when you take away those factors, what are you left with? Nothing. Because members of the jury, this wasn't a suicide, it was an accident. That's what makes sense. No. I don't know if there's a right ending to a story like Mr. Harper's, but I can tell you the wrong. And it's the one the defense is asking you to write. He was a person, not a paycheck. And their breaking point is $1 million. Side with the plaintiff. Thank you.
May I proceed with my remaining time, Your Honor? And at this time, may I request the timekeeper to give me my allotted time that I have left?
2 minutes and 56 seconds.
Thank you, Your Honor. May I continue? Please, court, opposing counsel. Ladies and gentlemen of the jury, opposing counsel asked you a few questions today. Now, I'm going to answer some of those questions, but I have a few myself. Now, let's start with Stevie Walker. Now, Stevie Walker didn't just hinge his investigation on this death certificate. No. He went far beyond that. In fact, he went far beyond the means of a rational investigator that normally would. You see, he not only he could have stopped that death certificate. He said suicide, no further, no claim. But instead, he wanted to make sure this was an accurate conclusion. So much so that he went to the scene, he took affidavits, he went to the police station, checked out the shotgun, and examined it for fingerprints. What more could he do to come up with a rational conclusion? A rational conclusion that pointed to Clint Harbor voluntarily and intentionally taking his own life. Now next, Dr. Trevino. She walked you through her 4 factors, but she also told you that these factors if not viewed holistically, her book can be taken out of context. And that is exactly what opposing counsel has done here today. Now you see, she did the best of her abilities on the stand with what she was given. What were those abilities? Well, she told you that Clint Harper, because of his age and gender, was more likely to commit suicide because of his marital situation. That he was separated from his wife, he was more likely to commit suicide. The fact that he formed his intent and then formed the courage while getting drunk is more likely to commit suicide. And the fact that he had a weapon with him at that time is more likely to commit suicide. Now, I do have a few questions today. First, Officer Jensen, the defense expert witness, he was an expert in forensics. Well, if Mr. Harper was using the gun cleaning kit near the time or at the time that the shotgun went off, why didn't he examine it? Would it have the same amount of titanium as the belt buckle? We will never know. Well, why was Clint Harper, a man that proponent of a big hunter, pointing a loaded gun at himself? Don't you think that a man would check to see if a gun was unloaded? Why did he have a gun at that apartment if he was just temporarily living there? Now, ladies and gentlemen, while Clint Harper was working those long hours, Krista Harper was out doing this. Now, was Clint Harper a person or just a paycheck to Miss Harper? Now, ladies and gentlemen of the jury, from the facts and testimony that you've heard today, there's only one rationally based conclusion. And that's on the night of June 15th, 2019, Clint Harper reached his final breaking point. Thank you.
Ladies and gentlemen, jury, that will complete our case for today. The jury has been instructed previously on the law, and now will be asked to convene in the jury room to make a decision in this case. All rise.
That was such a good closing.
That was really good. I was like, what was he? I was like, what? I don't know, like.
Hey, trial report, y'all wanna go ahead and get a picture while they're deliberating?
Efficient time.
So, picture time.
Yes. If you're on trial, I'd go ahead and make your way over here. Yeah.
Thank you. Thank you.
Y'all getting it.
Yeah.
I was like thinking about it, like, well,
So y'all are tough. Every piece of evidence.
thank you. Great job. Thank you. Great job.
What's up, darling? Hey, hello. That was so good.
Thank you. I appreciate it.
Dude, you're so good.
Now it's time for a drink. Now it's time
Oh,
for a
God.
drink.
I don't know about that.
Yeah.
I didn't mean it. Yeah,
And nice to see you doing it.